PG&E. A4&R agrees with the PD that PG&E's VPF spending plan requires rejection. Any defensible approval must await judicial resolution of PG&E's petition for writ review of D-23-12-036. Specifically, you need to know the proper construction of the following statutory terms: the nature of PG&E's interest in, quote, compensation, close quote, the scope of the Commission's review authority, and the meaning of the phrase, quote, to the extent it is not needed for Diablo Canyon, close quote. The Commission and PG&E, based on the litigation, clearly have diametrically opposite views about the meaning of those pivotal provisions. It would be financially irresponsible to spend money on PG&E's proposals until these differences are conclusively resolved. A4&R also agrees with the PD's denial of PG&E's requested tax gross-up of the fixed management fee. Despite the requirements of Section 712.8 C4, PG&E cannot point to a single mention in SB 846 of a tax gross-up. PG&E claims to be entitled to a gross-up to replicate a rate-based return on investment, but it ignores the fact that Diablo Canyon is fully depreciated and PG&E shareholders are making no new capital investment. A traditional rate-based return under such circumstances would be zero. So what changes to the PD should you make? A4&R recommends that you reduce the revenue requirement by the roughly $400 million identified in our reply brief. A4&R further recommends that you order PG&E to file an advice letter to correct the misallocation of $47.9 million in employee retention costs to the Edison and San Diego service areas. Those costs cover the period before extended operations, when all Diablo Canyon generation goes to the PG&E service territory. A4&R further recommends that you find that PG&E has not satisfied the regulatory requirements set forth in D-23-12-036, and that extended operation of Diablo Canyon through 2030 is not cost-effective, reasonable, or prudent. A4&R further recommends that you direct PG&E to provide the requisite 30-day notice to the NRC on January 1, 2027, of the company's intent to permanently cease operations at Diablo Canyon. The poison pill PG&E and DOE inserted into the grant agreement enables a clawback of the entire grant amount if the plant ceases operation before 2027. That creates a conflict between the general fund's interest in loan repayment and the ratepayer's interest in avoiding above-market costs. A4&R presumes, reluctantly, that the general fund's repayment interest will prevail. Consequently, you should put your turn signal on, get out of the fast lane, and steer toward the appropriate off-ramp to bring this expensive joyride to a safe and orderly stop. This exit should feature prominently in your response to Governor Newsom's executive order N-5-24. That executive order directs the Commission to identify, quote, orders it has promulgated pursuant to statutory mandates that may be unduly adding to electric rates, close quote, as well as, quote, underperforming orders whose costs exceed the value and benefits to electric ratepayers, close quote. That description fits extended operations at Diablo Canyon like a glove. A4&R also suggests you benchmark the Diablo Canyon cost against the reopening of the 3 Mile Island nuclear power plant. There, Microsoft signed a power purchase agreement at a reported $110 to $115 per megawatt hour price, about 24% lower than Californians will pay for Diablo Canyon. And Governor Josh Shapiro required that no costs be borne by Pennsylvania's taxpayers or ratepayers. An important lesson can be learned from that comparison. Once again, I thank you for the opportunity to address the Commission.
Thank you. Cal CCA.
Thank you, Your Honor. Commissioners, I'd like to just make 2 points in response to PG&E's comments with respect to its volumetric performance fees plan. And these comments respond to the California Coalition of Utility Employees on the same subject. First, the narrow point. Cal CCA doesn't agree that the plan complies with Section 712.8S of SB 846. Specifically, and this is the proposal that causes Cal CCA the most concern, PG&E proposes to spend volumetric performance fee funds on asset management, inspections, and maintenance at its hydro system infrastructure, and claims that that O&M work will increase resiliency and reduce operational and system risk. That is subsection F under section 712.8S. But performing additional maintenance or increasing staff at hydro facilities would not increase resiliency or reduce operational and system risk. Resiliency refers to the ability to withstand or recover from disruptive events. Performing additional maintenance and increasing staff at hydro facilities may reduce the frequency or duration of forced outages at those units, but doing so won't provide any noticeable resiliency benefit to PG&E's customers because when a hydro unit goes on outage, the lost generation is replaced through CAISO market dispatch. Second, the broad point. Certain parties today have made the point that volumetric performance fee funds cannot benefit ratepayers when they are sitting idle, and of course we agree. However, whether this commission directs PG&E to refile its volumetric performance fee spending plan in a phase 2 of this case, or directs PG&E to refile its plan after phase 2 of the OIR, the Diablo Canyon OIR resolves, it should establish the spending principles that Cal CCA, in turn, propose, such that PG&E has more direction before it refiles. And those principles are detailed in Cal CCA's briefs. Those principles will help ensure that PG&E's volumetric performance fee spending maximizes benefits to customers while avoiding creating competitive issues. Absent those principles, the risk is that PG&E will simply resubmit its plan with a couple more paragraphs of narrative defending the same proposals that, as the record demonstrates, have met significant opposition in this case. Now, PG&E and the California Coalition for Utility Employees emphasize that VPS spending proposals must meet criteria in section 712.8S of the statute, and Cal CCA agrees with that reading. But nothing in the statute or in D-23-12-036 prevents the Commission from establishing additional guardrails that ensure these volumetric performance fee funds are spent in a manner that maximizes ratepayer benefit. Not only would that be well within the Commission's discretion, it's a practical approach to streamline party and Commission review of PG&E's refiled plan, rather than replaying the litigation that played out in this proceeding. I'll close this out by again thanking Judge Adam Turk for the PD and to Your Honor and Commissioners for your time today. And I'll reiterate Cal CCA's recommendation here. We generally support adoption of the PD. However, we recommend the Commission delete conclusion of Law 13 for the reasons that I described earlier this afternoon and make other limited changes that we've described in our comments on the PD. Thank you.
Thank you. Next is CGNP.
Good afternoon, Judge and Commissioners. My name is Dr. Gene Nelson. I'll be giving the response for Californians for Green Nuclear Power. And my comments are we have 3 bullet points. They all relate to the laws of physics and engineering, which are the ultimate laws that this commission must be aware of in their timed up. Sorry. Oh boy. So there are 3 points. Point number 1 is that Diablo Canyon produces reliable 24/7 base load power. There is no way, no physical way to compare that with power that comes from solar and wind because those are inherently intermittent and unreliable. We already know about the phrase "be calmed." Mariners have known it for thousands of years. And time of day, well, if it's midnight, there's no sun. Those make it so that we can never compare solar and wind to Diablo Canyon. Then, when we look, opponents of the plant have proffered batteries. Well, batteries are merely a form of energy storage. They're a very expensive form, as our testimony has shown. We're talking just exorbitant amounts of money, more than twice the state budget, just to provide enough batteries for 24 hours, if that was available. No way. So batteries are not cost effective. Finally, when we look at nuclear power plants, we have to look at the history of what's happened during extended operation of plants around the world. And we know that nuclear power has been running for about more than 6 decades. And what we see is that costs go down, not up. So despite claims from opponents that this plant will be horrendously expensive and not prudent and so forth, the reality is that we can just simply look at what the testimony we cited from Lazard in their LCOE report published in June of this year, where they're looking at the total cost of power, including firming. And what they noted, and they had a special bullet point on it, $32 per megawatt hour is what they're expecting for extended operations. And that number comports very well with the numbers that we provided and other plant advocates have provided. So you get an incredible bargain with extended operation of Diablo Canyon. So that concludes my comments. Thank you for your time.
Thank you. Next is Coalition of California Utility Employees.
Can I go ahead? Okay, yes, please. Hi, everyone. Thank you so much. So I'm going to make a few quick points in response to some of the things that we heard today. The first is a number of the parties say that PG&E's plan lacks key details. Most of those parties can't identify what details are lacking, but they can sure tell you how they would have spent the money if it were up to them. TURN does indicate a few things that they see as lacking in PG&E's plan. They think there needs to be this should have been included in a ramp analysis. There should be a cost-benefit analysis, an RSE score, things of that nature. That's not a new suggestion. Those were things that were brought up in the rulemaking that were rejected by the commission when they established the standards that PG&E filed its application under and that we're reviewing the VPF spending plan consistent with today. So we struggle when looking at lack of key detail when PG&E is really providing the details that are required, and when the oversight that should happen is really going to come in retrospectively. And that is not simply something that's established in the commission's decision, but in the statute itself, the way that the review standard is set looks more retrospectively when we actually have spending to look at, when we have detail to look at. Right now, a lot of the concerns that we're hearing are really speculative about what PG&E might do with the money. But the way that the statute is set out, it says we look at that retrospectively. That is the oversight process established in the statute. And that's what the commission needs to follow in this case. Another point that TURN has made is that they want this spending to go towards capital only and not expense. And that's not consistent with the statute either. If you look at the critical public purpose priorities laid out in statute, they're worded quite broadly, and some of them lend themselves to expense spending almost exclusively, an example being priority E, which is, quote, communications and education, end quote. So interpreting the statute as not allowing any spending on capital would essentially read that out of the statute And that's really not what we should be doing here in the regulatory arena. Essentially, you know, I think what TURN is looking for is to direct the money and to create a regulatory framework that allows them to direct the money in the way they see best fit. And again, that's not the bargain that was struck between the political branches who drafted this statute. Another point is that I think essentially in TURN's perspective, they conceive of expense spending in a binary sort of way. Either expenses are accounted for in PG&E's GRC and recovered from ratepayers, or they're a shareholder obligation. There's nothing in between. That is an unworkable perspective, and looking at expense spending through that perspective sort of breaks down the statute, and we encourage the Commission not to adopt that perspective because, again, it reads out elements of the public purpose priorities that they can be spent on and the broad nature of the statute and the language that exists within the statute. And we think that the Commission has interpreted that correctly in the existing rulemaking decision. The last thing I'll say is that TURN's alternative plan, it doesn't comply with the statute for all the reasons that I've just mentioned, and another because they really conceive of the spending as reducing revenue requirement. That's not what the statute requires. It says increase spending or accelerate spending, not reduce spending. And so again, it's not the bargain they would have struck if they had the pen, and they didn't. And just because their plan didn't get adopted in the PD doesn't mean that other parties haven't had a meaningful opportunity to litigate what PG&E should be spending this money on. A number of other party proposals were adopted by PG&E. For example, the Small Business Utility Association got their recommendation included in PG&E's spending plan, which is $2 million for small business building decarbonization. So there has been a meaningful process. There has been a back and forth, and it's just, you know, the parties that proposed spending that are consistent with the statute were adopted. TURN's is not. And I think at the end of the day, this is about who has discretion, and SB 846 is really clear about who has that, and predominantly it is the utility, and that doesn't mean there is not a role for the Commission to make sure that this money, this unique compensation is spent appropriately. There is. That primarily comes after the fact in the retrospective review. Thank you.
Thank you. Next is CPUC.
Thank you, Your Honor, Commissioners. I'll quickly touch on the tax gross up for the fixed management fee as well as the volumetric performance fee spending plan. PG&E, in seeking the ability to add costs for the tax gross up to its fixed management fee, bases its argument on years of CPUC precedent on shareholder investment of capital in utility rate-based assets. That is not what we're doing here. That is not the case here. And PG&E's argument fails to recognize that the legislature intended the fixed management fee, $50 million per unit in 2022 dollars with escalation, to be the sole shareholder compensation for Diablo Canyon's extended operations. So don't change that aspect of the proposed decision. The statute is clear and prescriptive. Diablo Canyon is not business as usual. It's not shareholder investment of capital to which years of CPUC precedent should apply. So the only change you should make to the proposed decision on the fixed management fee is making sure you have the total fixed management fee correct, you know, addressing the typo, the miscalculation in the proposed decision as flagged by TURN. Then briefly on the volumetric performance fee spending plan, stay the course, reject PG&E's spending plan. EPUC agrees with our colleague Mr. Giesman's comments in this oral argument on behalf of A4NR. Given the pending Court of Appeals case, this is a situation where you need to get it right, not PG&E needs to get it right now. You need that clarity, and I urge you to stay the course and don't modify the proposed decision. Thank you again for your time today, for the opportunity to speak, and happy holidays. That is all.
Thank you. GPI.
Hello, Commissioners. I've had my say, so I will not give you any more, but I am here if there are any questions. Thank you.
Thank you. San Luis Obispo Mothers for Peace.
Notice of a single NRC sentence saying that there is no need for immediate shutdown is misleading. In fact, the NRC Petition Review Board is conducting a special review of Mother for Peace's witness, Peter Bird's conclusion that PG&E has greatly underestimated the seismic risk. If the PUC is to take official notice of anything, it should be the NRC's Petition Review Board proceeding. Thank you.
Thank you. Turn.
Thank you. I want to respond to comments by PG&E and Q. First, PG&E on the fixed management fee says that a tax gross-up is standard practice for any compensation received by its shareholders. Well, that's simply not true. Their statements apply to equity returns for shareholder capital invested in rate base. There's no rate base under SB 846, and this is not an incentive that is comparable to equity returns. SB 846 just says it's $50 million a year, and there's an escalator allowed. PG&E invented the idea that this amount is an after-tax figure. And it's worth noting the Commission has not provided a tax gross-up for similar incentives that PG&E has received through the years. Energy efficiency incentives between 2013 and 2019, PG&E received such incentives. Did it get a tax gross-up? No, it did not. So there's no precedent for PG&E claiming that any incentive that comes its way is automatically subject to a gross-up for taxes. With respect to the volumetric fees, PG&E claims that this money should be treated as compensation and that it should essentially be able to use it as it desires with minimal Commission oversight. But the statute prohibits the money from being used to benefit PG&E shareholders. They're not actually compensation if you can't use the money to benefit your investors. And enforcing this prohibition requires the Commission to engage in rigorous upfront and after-the-fact review. Q claims that the law simply prohibits the Commission from conducting a broad review of PG&E's plan, and there's no recognition that parties can submit alternative plans. The basic argument you're presented with here is the only way to modify PG&E's plan is to ask PG&E very nicely if they will make changes. That is literally the only way that's been proposed. That simply doesn't cut it. The Commission has already held that it can modify, reject, or amend PG&E's plan or adopt an alternative plan, regardless of whether PG&E supports such changes. The Commission should hold firm on those holdings, and that's the D-23-12-036 decision taken last year and the decision denying rehearing. The Commission has also pointed to Section 451 as providing broad authority to regulate the use of ratepayer funds. PG&E points to a series of programs it wants to fund with the volumetric fees. It talks about deferred maintenance at hydro generation. We're concerned that could cover overspending that would otherwise be absorbed by shareholders. It also includes the cost of maintaining a safety certification that PG&E says even if it doesn't get the volumetric fees, it will maintain that safety certification. So not clear what kind of incremental benefits we're getting. 500 batteries for customers at risk of outages. There's no indication as to how many customers are eligible, the battery configurations. There's tons of details that are missing. And it was never mentioned as an important initiative before PG&E submitted rebuttal testimony. Its electrification customer experience program it wants you to support funding. Never mentioned before rebuttal testimony. No quantitative outcomes identified. We asked PG&E what they want to do with the money. About half of it would be used to train their customer service reps to keep customers informed of the latest electrification technologies and services. There's no evidence that customers are calling PG&E customer service reps and asking them for advice about buying electric vehicles. Why is this a top priority? PG&E says, don't worry about whether it's going to engage in reasonable use of the money. There's always a compliance review. That's when you'll have your chance to determine whether the money was well spent. Well, first of all, letting PG&E spend the money on its preferred uses would divert resources that could be used for more valuable purposes. Secondly, when PG&E says it wants a compliance review, you have to understand this is not a meaningful review of spending. This is a ministerial process under its proposal. There'd be no review as to the reasonableness of spending, no clear way to determine whether shareholders have benefited. The only thing it wants the Commission to determine is that the money was spent, and that's not enough. Q claims that SB 46 doesn't contemplate spending volumetric fees on capital. Not sure where they got that from. Customer interconnection costs are specifically identified, and if you look at Senate Bill 410 that authorizes PG&E to do interim rate recovery of energization spending, it references the use of volumetric fees from Diablo Canyon to help fund that effort. And the Commission approved a rate-making mechanism to make that possible earlier this year in Decision 24-07-008. PG&E says that delaying the use of volumetric fees would result in a tax obligation that would diminish the value of the funds. First of all, PG&E will be able to receive a deduction if the funds are spent on expenses, even if it occurs in a future year. So the tax impacts are neutral over time. And SB 846 doesn't authorize them to take a tax gross up on this. Finally, PG&E says delaying spending will prevent ratepayers from receiving benefits. And they say customers won't get those 500 batteries we've promised. That's $5 to $15 million out of $167 million spending, 3 to 9% of the program, not a material amount for a highly questionable program. We think spending money quickly on wasteful or unnecessary programs is just not a good use of the money. It's better to get it right. Thank you.
Thank you. PG&E?
Good afternoon. Thank you. We've heard a lot from the parties about the PD and about the proposed fee uses here today. We understand that stakeholders can have different perspectives on how they'd like the arrangements to Diablo Canyon to have turned out. Respectfully, some of the recommendations here brought forward by interveners and portions of the PD are inconsistent with the legislative direction. They create hurdles to compensation, to adequate compensation and spending that have no basis in the statute. Yet this isn't the time to revive legislative advocacy, but rather to implement the clear directive and statutory intent. So we think it's important to not lose sight of a couple of key issues. One, the state asked PG&E to extend Diablo Canyon, and we answered the call. SB 846 reflects the careful but clear balance struck by the legislature on compensation, including a limited shareholder return and a streamlined process for accelerating priority work. The fixed fee is set lower than our historic compensation by statute, and the PD would lower it further still. Income tax gross up is so commonplace that it's not necessary to call out in statute, just like it doesn't call out compensation for property tax payments either. As I quoted before, income tax gross up is a standard cost of service item. On the fixed fee, or the performance fee, this is a unique arrangement in the utility industry, and it was put in place to simplify the process for putting those fees to good use for customers. But that's not what's happening under the PD. We believe the PD should be modified to implement that legislative intent as quickly as possible. There should be a tax gross up, just like in every other cost of service arrangement that this commission approves, to ensure that PG&E is adequately compensated, as SB 846 envisions. And as the commission itself has indicated, on the volumetric fees, we have discretion to spend the money so long as it falls within one of the priority uses. We have more than met that standard here. We recognize that parties want more process or more of a say in how we spend those funds, but that's not what SB 846 requires. So the commission ought to approve our spending plan in 2025 so that we can put those dollars to use for customers as soon as possible. With those changes and a few relatively other minor ones in our comments, we believe the PD should be adopted. And lastly, before I wrap this up, I do want to acknowledge again all of the work that has gone into the Diablo Canyon extension over the past two plus years. It's not just the hard work of the folks at the plant, though obviously without their efforts to operate the plant safely and reliably, we wouldn't be here talking about extending Diablo Canyon today. But also the work of the commission, the judges, stakeholders, commission staff, who've all had to squeeze new unexpected rulemakings and cost recovery proceedings into a crowded docket. I think the same goes for other state and federal regulators to take a careful look at the issues around extension in a compressed timeline. Despite all that work, as I mentioned in the opening statement, this extension is going to yield substantial benefits for customers in terms of affordability, for the state's goals, and for the environment. We appreciate your careful review of our requests so that we can get to work delivering those benefits for customers as quickly as possible. Thank you.
Thank you. Next, I will invite questions from the commissioners. Commissioner Douglas.
Thank you. I had a couple questions, and I thought I would actually start with Cal CCA, if I could. Your comments on conclusion of Law 13, I was just maybe wanting a little clarification about the issue you see and maybe a response or any perspective from PG&E on your comments. Thanks.
Certainly, Commissioner. I'll try to provide a little bit of clarity, and then maybe if you have any follow-up questions, I'll take those. The issue that I described in my opening statement relates to conclusion of Law 13, but the discussion related to that conclusion of law is on page 32 of the proposed decision. So just for your reference. And the discussion on page 32 sort of lays this out, but on that page, it talks about a ruling that was issued on October 8th, 2024 in PG&E's ERA forecast proceeding. So that's application 240509. Just to get our bearings on timing here, that ruling was issued, when this proceeding was fairly advanced. We were, I don't want to get my dates wrong, but this was after initial briefs were filed, and PG&E was very close to filing its fall update testimony. So just to give you a sense for when this issue was playing out in PG&E's ERA forecast proceeding. In that proceeding, in response to that ruling, and then in its fall update testimony, PG&E proposed certain, and I'll use air quotes, mitigation measures that, according to PG&E, were aimed at mitigating over or under collections in the ERA balancing account. So that's the issue that I was talking about. Now, Cal CCA opposed PG&E's proposal in that proceeding on several bases, one of which was that, in our view, that proposal was beyond the scope of the ERA forecast proceeding. And the PD in PG&E's ERA forecast proceeding, in fact, agrees with that view, notes that PG&E's mitigation measure proposal is outside the scope of that proceeding and does not adopt the mitigation measure. Now, returning to this proceeding, we have a reference here to this mitigation measure for the RAMPB. And our view is that, well, one, that really relates to a separate proceeding with a separate record. And so it shouldn't be sort of imported here into this proceeding at a late stage without discussion of that proposal here. And then just as a practical matter, since it has not been adopted in the PD and PG&E's ERA forecast proceeding, to the extent that PD is adopted, it would be moot here. So I'll stop there before I go into more repeating my argument, but hopefully that's helpful.
Yeah.
I just wanted to ask a follow-up question for you on this. I appreciate that ERA is complicated enough, and bringing ERA into this proceeding with its own complexities is challenging. So just as I think through your description of conclusion of law being moot, given the as-published outcome in the ERA forecast PD, I do want to understand, is your view that conclusion of law 13 would continue to be moot if we adopted that ERA forecast, but at some point in the future, we opened a ERA and PCIA rulemaking that considered potential changes to how we go about forecasting ERA, including PCIA and the RA benchmark within that docket? So I'm going to, hopefully that hypothetical is clear, but please let me know if I've made it not very clear.
As clear as things get in the ERA world, but thank you, Commissioner. I think I understand the question. The short answer to your question is yes, because the way we read that conclusion of law in this PD is that it references a very specific proposal that's being made in the ERA forecast proceeding. And I think the reason why I read it that way is because of the discussion on page 32. Now, you asked about the possibility of changes to, say, and I think this is what you said, but maybe I'm reading into it, the changes to the market price benchmark or the methodology that, from which the market price benchmark is derived, that occurring, being developed in a separate proceeding that, say, plays out in 2025. I think in our view, that would be sort of the correct process, that it would be considered, changes would be considered in a rulemaking and then brought into rate-making proceedings following that rulemaking. However, to let stand a conclusion of law in this proceeding that really relates to rates that will go into effect next year, and then to leave a placeholder for changes that, frankly, we don't know what those changes are going to look like. They could cut in many different directions. In our view, trying to figure out how those changes, if any, should be applied to rates that went into effect potentially several months prior, that's very thorny, and certainly would require more than a Tier 1 advice letter. So in our view, if there's going to be changes 2025, we'll have an opportunity to then bring those changes to the extent appropriate into a future forecast proceeding, but should not it should not be assumed that should be applied to 2025 rates that are going into effect soon.
I think I follow you, and I just want to make sure that I'm understanding you correctly. Is it fair to say that if a rule were to change 2025 era costs before the end of 2025, you would say that conclusion of law 13 would be concerning, even if that rule doesn't come in the era forecast docket, but if that came in another docket before 2025 era costs are finally trued up?
Yes, I agree with that, confirming that.
Thank you. Did PG&E or other parties have a perspective on this?
Just briefly, I think the conclusion of law reflects the common sense proposition that if the Commission makes changes to the market bench price methodology that affect the way it's treated in Diablo Canyon proceeding, there's an existing mechanism that would allow that to be imported into this proceeding. That feels like an efficient use of resources and process.
All right, thank you.
John Giesman on behalf of the Alliance for Nuclear Responsibility. I'd remind you, Commissioner, that in this proceeding, the forecast itself is determinative of the recovery that PG&E will ultimately be able to achieve, plus 15%, so that if you modify the forecast methodology, you'll need to take some sort of step to assure that there's not an overcollection or undercollection, given the SB 846 cost recovery provision. That's the reason that we suggested, no matter which forecast methodology you choose for substitute capacity, we suggested that it be capped in this year at the amount that PG&E has acknowledged it could have purchased that substitute capacity for.
All right, thank you. All right, I've got another question, and I think I'll go to turn for this one. And I'm just going to find it here. So here it is. So, Mr. Friedman, you said in your initial argument, you made a statement, and I wrote it down, maybe imperfectly, but it basically said, in order to find any use of the funding permissible, we would have to find that any kind of shareholder benefit is impossible. And I found that statement to be pretty broad, and I just wonder if there's any clarification, and in particular, where in the statute you find that kind of restriction.
Thank you, Commissioner. So my argument is not that the Commission must make such a determination, but that it should. And that's because this is a very thorny issue. Money's fungible. PG&E has the ability under its proposed spending plan to take VPFs and use it on initiatives and work that might otherwise be funded by its shareholders. What that does is that frees up money that shareholders don't have to pay and allows shareholders to directly benefit. There's a bit of a shell game that we worry about, and policing this is going to be incredibly difficult for the Commission, especially if it goes along with a very constrained review process at the back end. So the way to reduce risk here is to ensure that the way that money is spent up front, the guidance that's provided in the plan, is only on items where there's no chance that we're going to end up having this conflict that the Commission is going to have to deal with later on. So again, we're not saying you have to do this, but we're saying we advise you to do this as a way to ensure that we don't end up with problems on the back end. PG&E wants to use this money essentially to spend on any area where it has overspending on GRC authorized expenses. That's kind of their overarching view of how to spend the money for existing expense programs. There are many reasons why PG&E could end up spending more on expense-related items, including imprudence. But what they want to do is to prevent the Commission from reviewing the reasons for the overspending and simply say money spent equals additional work done, box checked, plan is compliant. And we don't think that's a good way to go. We think that spending it on other initiatives where the Commission can track more carefully and ensure that shareholders aren't benefiting, and particularly we think energization is a perfect example given the massive request for spending that's pending. That's a way to avoid this challenge.
So you started out, it sounded like, talking about double recovery, talking about how we avoid double recovery, and then you went a little more broadly. And when you didn't directly address my question of where the statutory language is supporting the argument you're making.
Well, the statute says that shareholders cannot receive a direct benefit, and PG&E has acknowledged this in all of the briefing in this case. So what is a direct benefit? PG&E's interpretation would be, I believe, that it cannot provide a return on rate base to its shareholders. That's how it wants to constrain the statutory language, but that's not what the statutory language says. It says that shareholders may not directly benefit, may not receive profits, but there's different ways that profits can be received. It's not just through return on rate base. You pay for an expense that otherwise would be borne by shareholders. Shareholders are relieved of an obligation, and they therefore make more money. That is a direct benefit that is conferred through the use of this money. So that's the way we see it relating to the statutory framework, which specifically says shareholders cannot be enriched or benefited. And return on rate base is only one way that that would occur.
All right, thanks for sharing your interpretation. I mean, I'll direct, I think we're all looking at section S2 here. The operator shall not earn a rate of return for any of the expenditures. They can't and they shall not increase public earning per share. No double recovery in rates, and then there may be something else there, but that's the same provision that you're referring to, right?
Yes, and we briefed this extensively, so it's all in our briefs.
Got it. All right. One more question for you. In your comments, you brought up a number of things that you'd like to see in PG&E's plan, including cost-benefit analysis and now risk spend efficiency, basis for choosing the uses of the funding. Again, what's the basis for that in your view?
Why would we recommend it, or are you asking me what's the basis in SB 846?
Yes, the second.
Well, the basis in SB 846 is that the Commission must review the plan, and the Commission has already in two separate decisions affirmed that it may review, modify, adopt an alternative plan. If the Commission has already held that, that must mean that the Commission has the ability to decide that it doesn't like the way that PG&E is proposing to spend the money and that they should spend it some other way. Well, what basis would the Commission have for making such a determination? It would be a finding that PG&E's proposals don't make sense don't provide real benefits. And we think that we don't understand how PG&E picked the proposals that it proposes to spend money on. It seemed arbitrary and haphazard and last minute. So we asked a lot of questions in the case. Why did you decide to spend it on this versus something else? What are the relative benefits of this spending versus another type of spending? There were no answers to that. They basically said, we didn't do any of those analyses. And we don't have to, is their view. Their view is they can spend it on whatever they want. And we disagree.
That's helpful. I don't have any more questions for Turn. I think that's all I've got right now.
Judge, if it's all right, I'll ask a follow-up to that last question and just turn to PG&E. I mean, we heard that you submitted the proposals in rebuttal testimony, and so just, you know, wanting to hear if there's a response to why, if these are proposals you're submitting for us to review, why were they not in the original testimony? Is there, you know, I think we're hearing that there's some suggestion that they weren't well thought out or that they were somewhat arbitrary.
Sure, I'd be happy to. I mean, I think the simplest answer is we've submitted our plan and we engaged in the process in good faith. We read what other parties submitted for their proposals, and we made some changes to our proposals from our opening testimony to our rebuttal testimony. As you heard from some of the parties, we adopted proposals of parties. We agreed to certain principles that would limit how we would spend some of our funds. And then we went to hearing on these issues. So we believe we were engaging in the process in good faith, taking feedback from the parties and adapting our plan to address those. It's true, we didn't adopt everyone. We didn't adopt Turn's proposal around spending on capital interconnections, but we did provide a lengthy explanation as to why that presented challenges for us, both from an accounting and a tax normalization perspective. So we did engage with it. We didn't just ignore it. We talked about it. We explained why it presented challenges for us, and we ultimately did not choose to adopt that in our proposed plan.
Is there any response? I just wanted to give you a chance to respond from Turn. Mr.
Thank you. I guess I would just point out that the revised spending proposals that came in rebuttal testimony, for most of them, none of them were requested by interveners. The idea that PG&E was adopting recommendations that other parties made is simply not consistent with the record. They came up with new proposals at their own initiative in rebuttal testimony. This is a bad practice. It's very hard to litigate when you don't have another chance to submit testimony, right? The record is closed at that point except for data responses and cross-examination. So many of these new initiatives we saw for the first time. No one had ever suggested that they do them. These were not responsive to party concerns. This is just PG&E changing its mind and coming up with new ideas at the last minute. And we don't think that's a good way to justify spending.
Okay, thank you. I have another question. I heard a comment from Q regarding the standard of review, and an argument was made that the standard of review should be changed to preponderance of evidence. And I was wondering if Turn or other parties wanted to respond to that, if anyone has comments. So I'm not sure if Turn is the right party.
Well, I guess I'll just say that,
like, maybe we'll let Mr. Giesman and Mr. Friedman respond and then leave it at that.
Our view is PG&E does have the burden to demonstrate that their plan is compliant, but the commission holds the cards on this one as demonstrated by two separate decisions in which it has specifically invited alternative proposals. And we did present contrary evidence to suggest that PG&E's proposal was not reasonable. We had a whole section of our two briefs devoted to this, identifying flaws, and we don't think that PG&E adequately responded to those. Their basic response is that they don't really have to respond because in their view, they get to do what they want with the money. So this is a weird issue in a lot of ways, but we don't think they satisfied their burden of proof because they did not respond in many cases to many of the critiques that we raised.
Okay, thank you. Mr. Giesman, did you have a response? Basically, the issue is, should the standard be preponderance of evidence or conclusive evidence, or is it not necessary to determine that?
We think it should be the preponderance of evidence. We think that the Q did a word search, seized upon the word conclusory, and misinterpreted that as the standard that the PD applied. We believe the PD applied the preponderance of evidence standard and that that's the appropriate one here.
Understood. Thank you. That's helpful. Ms. Sharif, I saw you coming up. I want to just give you a minute quickly.
Thank you, Your Honor. Nora Sheriff for EPUC. Thank you, President Reynolds. I just wanted to say that EPUC agrees that the PD got it right on the standard of evidence, and I don't think it should be changed. We did address it in our brief.
Okay, thank you. That's helpful. I don't have anything else. Commissioner Baker?
I just had a couple tiny questions. Mr. Friedman, does TURN oppose including O&M costs in the list of projects that the utility would come forward with?
No, we have suggested that O&M could be included if it's tracked in a balancing account, and we identified wildfire mitigation expenses as one category that would be that would satisfy our concerns.
And then could you talk a little bit about how, if it's in a balancing account, how that will address the incrementality issue, or could address that issue?
Well, in many ways, we believe it frees up money for PG&E to pursue other priorities. PG&E comes in front of this commission, in front of investors, routinely saying that it's cash constrained. It simply cannot engage in all of the work that is expected of it because it doesn't have enough money available. This frees up that money for PG&E to be able to go and do that accelerated work. That's how we believe it satisfies the standard. And in some cases, you know, with respect to, for example, energization work, this is all incremental work that they're doing. So you start to get into these kind of religious debates about what does the word incremental mean. If it's new work occurring on the system, we think it satisfies the test.
Thank you.
I have a couple of questions that I think will be mostly for TURN and PG&E. First, I want to just make sure that I'm understanding the calculation error identified by Mr. Friedman earlier correctly. As I understood you, and I don't want to mischaracterize it, so I'm going to ask you to re-explain it, but I understood you to be indicating that $167 million is too high given the text of the PD and includes a tax gross up. Was that correct? And if not, could you please correct me?
Sure. This $167 million refers to the volumetric plan, and we don't see an error there. The error that we've identified is on the fixed management fee issue. And specifically, the proposed decision states that PG&E requested $112.7 million before taxes, and it approves $108.5 million. The problem is that, and so it's adjusting essentially for the escalation factor where it adopts TURN's escalator versus PG&E's. The problem is that that $112.7 million includes the tax gross up. So the decision, the PD says, it's not allowing the tax gross up, but the face value number that is provided includes the tax gross up. And in fact, the reference is to a table in PG&E's testimony that highlights the fact that it's both. So in order to have consistency through the decision, the number should not be $108.5 million, but $74.318 million to be precise. And that's page 1 of our reply comments that we laid that out.
Thank you. And could I just hear from PG&E? While I understand you think that there should be a tax gross up, do you agree fundamentally with the calculations that TURN is suggesting here?
On the calculation error, we identified that in our opening comments. It's against our interests, but we raised it and identified it, so we do agree that that should be corrected in the final decision.
Wonderful. And then switching gears, you know, one problem I would like to hear a little bit more from both of you about and from any other parties who may have something to share. So I appreciate that this proceeding has been moving fast. This was filed in March of this year. Here we are in December. One of the challenges that I think confronts us is that the statute looks for, when we're talking about the priority projects, the statute looks for acceleration of PG&E's work in those areas. We are on the verge of 2025, where that work presumably would happen. And the concern that has been raised, and that the PD ultimately rejects the spending plan on, leaves us in this awkward position where what do we do from here to accelerate projects in 2025? And I wonder if maybe Chern could start by speaking to what it suggests we should do, thinking very specifically about 2025 project costs. And I wonder if we could hear from PG&E in response to that and the other parties that may also wish to comment on it.
Thank you, Commissioner. In the decision issued last December, the Commission noted that its directives regarding the volumetric fees plan applied to 2024 and said that issues relating to spending post-2024 would be addressed in Phase 2 of the rulemaking. And so we did address those in the rulemaking. Comments have been submitted, and we're expecting a proposed decision at any time. And we put in those comments specific proposals for what should guide 2025 and beyond expenditures. So it is our hope that there's going to be a proposed decision and a final decision by the Commission sometime soon in that rulemaking, and it is explicitly by the scope supposed to apply to 2025 and beyond spending. And we think that once that's out, PG&E comes back with another plan, and then we relook, and the Commission get a chance to approve it. But so that's the sequence of events that we think is actually nicely organized already. It does not require some brand new process. But I also would just urge the Commission not to rush to allow money to be spent if it will not be spent for purposes that are valuable. And this is also the case of first impression. This is the first year of the spending plan. What you do in this decision will have consequences for all of the future reviews of spending plans, and there's $1.3 billion that PG&E is expected to collect through 2030. So doing it right is better than doing it quickly.
A couple of points. I think Mr. Friedman continually refers to the proposals are not the most valuable. I don't think we've argued anywhere that these proposals are the most valuable. We have not tried to justify them on that basis. What we've done and what we believe we put forward in our application and in our testimony is that these uses fall within one of the 6 priority categories. And the Commission has previously said that we have discretion on how we use those fees so long as it falls into those categories. So we are very comfortable and have laid out our basis for why those categories, why the work falls into one or more categories, and why we show no double recovery or no shareholder disbursements from it. So we believe we've met the statute on that. That said, I'm not understanding your question. We do, and it's in our primary interest here, to put those fees to use for customers as quickly as possible. And so while we'd like to have our plan approved, if we need to have an alternative way to get those approved so that we can put them to use in 2025, we're open to some other process. That's like a supplemental advice letter process. I think that would be an acceptable path. I will say it's important from our perspective that we have clarity on this work, approved or not, by the end of April, because if we don't have it by then, it's impossible to deal with in our work plan and accommodate in the course of the year. So that's trying to be responsive and pragmatic and realistic about what it would take, but also express some openness to some additional process that would make sure we can put the funds to use for customers quickly.
Thank you. Nora Sheriff for EPUC. EPUC has expressed concerns with an advice letter process in this proceeding because of the lack of protections for ratepayer advocates in that process. There's no real way to have workshops or get an adequate voice for the ratepayers. The Commission has in the past held what I have referred to, and I think others have referred to as rocket dockets, very quick applications, usually in connection with statutorily tight timeframes, but that could be something that the Commission could undertake to do here once you have the Phase 2 decision and the greater definition on what PG&E and the detail that PG&E needs to put in an expedited application process. That is something that EPUC would support. Thank you.
John Giesman on behalf of the Alliance for Nuclear Responsibility. I want to hark back to what Mr. Friedman said and emphasize the importance in D.23-12-036 to that Phase 2 rulemaking. The scope of the first phase of the rulemaking was confined to 2024 as it related to VPFs. In 2024, PG&E indicated they weren't likely to have any VPFs collected. So it was a bit of an artificial case. It wasn't clear because PG&E had not submitted a forecast of Cal ISO market revenues in phase one of the rulemaking, whether you'd be confronting a net surplus or a net deficit. We felt very strongly, and we confined ourselves in phase one to comments on 2024, and we agreed with Southern California Edison Company and San Diego Gas and Electric that those monies ought to be kicked back to ratepayers. It benefits everybody that way, if there are any monies at all. Well, in 2025, based on the October update that PG&E provided to its cost forecast, they're projecting a $761 million deficit compared to Cal ISO market revenues. I would submit to you that is a material change from the assumptions for 2024 that the phase one of the rulemaking was based upon. Now, they're proposing to spend $160+ million on the VPF projects, and in their October update, you'll see a line on table, I believe it's 4-11, that says, as a percentage of the net revenues charged to ratepayers, something on the order of 32% in the PG&E service territory and 12.5% in the Edison and San Diego service territories. Ask yourself, do you really think the legislature intended to create an excise tax on Diablo Canyon electricity production that would be used to fund projects completely unrelated to Diablo Canyon? In this era of affordability challenges, I would submit to you that D-23-12036, addressing the phase one issues, probably would be and should be rethought in phase two. Thank you very much.
If I may, one comment on Ms. Sheriff's comment. An application process, there's not time for us to prepare and go through that process. So I don't think that would be a solution here to your response, Commissioner Reynolds.
Darian, on behalf of the Coalition of California Utility Employees. And the question was, how do we make sure we're getting the money out quickly? Because that's what the statute requires. And in our comments, we say, look at each of the proposals individually. Some of them are really clearly compliant with the statute. I think a good example is the $2 million for small business building decarbonization. There's no reason to delay spending on that and delay approval on something like that because there's concerns about other proposals theoretically. And I think if the commission is unwilling to approve funding for that type of project because it wants to deny the whole thing and then relitigate what the standard of review is, that's not really appropriate in what we should be doing here in the perspective of Q, because we've already decided those issues. The parties here had an opportunity to express what they thought the commission, how they should limit the spending, and those were rejected ultimately. That's not what we're here to do. We shouldn't be moving the goalpost. Let's approve the proposals that are clearly compliant and use the compliance review at the back end to make sure that they're spent appropriately. And if there's additional information that the commission would like to have to make sure that some of these proposals are compliant, have that information be provided in an advice letter process and potentially even, approve them contingent on additional information being provided in an advice letter process that demonstrates it's compliant with the law.
Greg Morris for Green Power Institute. In our comments, both in this application proceeding and in the underlying rulemaking, we've proposed that we consolidate the deliberations about the VPF funding spending plans because we've got these two different things going on. They're not simultaneous. If we wait for the other proceeding to have a decision, then we're delaying things. If we combine just the VPF spending plan parts of the two proceedings, we feel, and consolidate them, we feel we could get through them properly and quickly.
Commissioner Haq, do you have a question?
Yeah, just one question. Given the discussion about wanting to get this money out quickly to be spent on projects for 2025, I wanted to know from PG&E, one of the categories, the contingency uses for safety and risk is $40 to $60 million, but it's not clear what or whether that money will actually be spent in 2025. So I guess I wanted to hear a little bit from PG&E about what they're anticipating spending that money on, or would that be going to offset balancing accounts like I think Commissioner Baker had proposed, or if it's not spent, what happens to that money?
Thank you. In our application, we proposed a waterfall of uses because we're obligated to spend all of the money, and so we also don't know exactly how much we're going to spend in each of these categories. So we primarily had a number of programs that had specific uses that we would spend money on first. Those had a range of actual costs because we were trying to accelerate work, so we were required to put this in an application last spring, and so we had a range of what those costs would be. If many of those costs came in on the low end of the range, then there would be excess money available. Our thinking there was for these contingency uses would be for, again, in response to Mr. Friedman's comments, not for cost overruns, but rather when there's emergent events that require additional work at that time. So rather than slowing or extending the duration of that work to let's say, improve resilience after a storm event, respond to a storm event, we would know that we can go and do that quickly and would have this money available to do it. This could, and probably would, result in us asking for some of this money we could ask for in other proceedings later, but we wouldn't because we would have used this money first. So that's how we avoid double recovery. It will reduce what we ask for in subsequent applications. So there's a couple of different flavors here. There's new programs or expanded programs that are incremental. Then there's work that's emergent that would fall into these fallback categories. And then there was a final fallback category, which was if there's any money left over at the end, we would dedicate it to reducing the cost for Diablo Canyon in the following year. So that was the waterfall approach that we took to sort of the order of priority for our spend, which we believe, Max, is in line with the statute, which talks about a plan for prioritizing the uses of the fees. So that's the kind of the language in the statute that we keyed off of for that waterfall approach.
Matt Friedman with Turn here. Commissioner, thank you for the question. We looked into this category and we asked PG&E what they would spend the money on for contingency uses for safety and risk. And they identified costs for outage response or repair of unsafe conditions to the distribution infrastructure or storm events. So we probed a little deeper and said, does that mean PG&E won't respond as promptly to outages if the money is not available? And they said, no, that's not what it means. We said, does it mean that you're not going to repair unsafe conditions that emerge if the VPFs are not available? They said, no, that's not what it means. We will respond and we will maintain the system safely. So what this basically looks like is the forecast rate making in the general rate case means utilities taking a risk. Sometimes it overspends on expenses and sometimes it underspends. That's the bargain. PG&E wants to modify that deal with the VPFs. They want to use these volumetric fees so that they cover the overspending and they would essentially retain underspending on other GRC expense categories. That's the game. In addition, they said, well, what about storm events? We have to respond to storms. And we said, but you should be able to recover that money through the SEMA and WMSE. There are balancing accounts. There's a whole process set up for recovery of storm events, costs related to storm events. But the difference between recovering it that way and this way is recovering it that way, there's a reasonableness review. Recovering it this way, PG&E adamantly opposes a reasonableness review. So it wants to shift these costs from a forum where the commission can review whether the money was spent wisely to a forum here where PG&E just wants to be able to check the box and says the money was spent and the reasonableness of the spending may not be considered. So that's why we think that this category, contingency uses for safety and risk, is very problematic, and it encourages mischief by PG&E to the detriment of ratepayers.
Could I ask a follow-up to that, to PG&E? And I think I heard you say that you wouldn't not do the work, but instead you would not request cost recovery for the amounts that you spent for emerging risks or response to events in, for instance, a SEMA. How would the commission determine, or how is PG&E thinking about the overlap with the GRC? I think when I'm hearing Mr. Freeman make the point that some of these things sound like regular costs that would be included in the GRC, and so how are you distinguishing between just not, kind of double dipping on your GRC versus something that would be tracked in a memorandum account like a SEMA?
Sure, and so some of this could be stuff that could be tracked in a memorandum account like a SEMA, and so I think there was a couple of different flavors here. As I mentioned, there's a menu of ways in which this could apply because we don't know how this is going to turn out in any given year. So the way you detect is different is some of them are new and different programs that are work that was not proposed in our last GRC. Some of it is work for a SEMA that allows us, because we have access to this money, we can accelerate that work. We can do it quickly. So that's what ties back to the statute there. So yes, we could book it to SEMA. Yes, we could perhaps have an application for it and recover it later. But rather than wonder about that and try and decide how do we prioritize the timing of that, we can spend the money to accelerate the work quickly. So there is overlap. There's nothing that says that this work can't be spent on work that's eligible for recovery in the GRC or in some other application. It's to accelerate the work to make it happen faster and more quickly. And it circles back to your initial comment, which was, if there's a safety and reliability issue, we're going to deal with it. So that's the basic requirement of operating a utility. But the question is, sometimes you have to make choices about prioritizing when and how that fits into your work plans. Having this money available, and we tie it to specific, matter codes is how it's tracked specifically, would allow us to accelerate that and do that more quickly so we can bring those benefits to customers. And we also has knock-on savings of, agreed, not having to apply for that later, not having to go through that process. Yes, it's that too. But the main point of it is to accelerate that work and give us confidence that we can fund it quickly so that we can restore service or improve work or increase resiliency for customers.
Just want to ask a brief follow-up, and I don't want to get too bogged down in accelerating SEMA work because I don't think that PG&E would delay storm recovery in order to wait for a SEMA application. In fact, those costs have to be incurred before you seek recovery. But I do want to understand how you would think about future forecast GRC costs, which I do think are a different category than costs that are tracked in memorandum accounts and present a different kind of accounting challenge. I mean, if you were to recover costs using this mechanism that you would otherwise typically forecast in a GRC, and you would have discretion to move money around once your GRC funding is approved, how would you demonstrate to us that the money you have spent from this fund is not then going to show up in another forecast GRC in the future?
Yeah, understand the question. Candidly, it's easy right now because we've got an approved GRC, so we're talking about work that's incremental, and so it's easy, we thought it was easy this time around to show, hey, this is new work that we just identified a need for in 2024 to spend in 2025. We know it wasn't something that we had planned before in our GRC, so it's incremental. I would agree that showing will be more challenging to make once we filed our next GRC application, and maybe, and I shouldn't speculate about what that will look like right now. But one of the ways to address that is by having new programs or programs that we know are going to be in future applications that are going to be addressed outside of the GRC, but that we haven't filed that application yet, but we want to spend some of this money now to accelerate that work. And I can think of examples that are even mentioned in some of our funding here around some work to, accelerate some of our, begin some IT processes that are going to allow us to bundle work and be more efficient in our spending of interconnections. We start that now, that's great. That makes it cheaper later. It brings the benefits to customers faster. But there's also going to be another application later to address the larger project and the larger scope of work. So it is tricky to try and fit within all of these categories, but I will say we're confident that we can show this because we're not, as Mr. Friedman said, we're not playing a game here. We're trying to get work out to customers as quickly as we can. Our goal here isn't to enrich shareholders with this money. It's to spend this money on customer programs as quickly as we can.
Any further questions from the commissioners? Hearing none, this concludes the oral arguments. Thank you all for your participation. We're off the record.